Good afternoon, everyone. We are on the record. Today is Monday, the 22nd day of September in the year 2025. This is a City Council caucus meeting of the Jersey City Municipal Council. We had a scheduled 4 p.m. start. The clock on my cell phone is showing 4:02 p.m. May I have a roll call for the commencement of this caucus? Councilperson Ridley?
Here.
Councilperson Hewlings will not be in attendance. Councilperson Baggiano? Councilperson Soleil is not here yet. Councilperson Solomon is not here, and Councilperson Gilmore is not here. Councilperson DeGise,
Here.
Councilperson Rivera,
Here.
and Council President Waterman. We have 5 council members in attendance at 4:02 p.m. On behalf of Council President Waterman and the members of the Municipal Council, in accordance with New Jersey Public Laws of 1975, Chapter 231, the Open Public Meetings Act, also known as the Sunshine Law, adequate notice of this meeting has been provided by the posting on the bulletin board of the first floor of City Hall. The annual notice, which is the schedule of meetings and caucuses of the Municipal Council for the calendar year 2025, and filed in the office of the city clerk on Friday, November 15th, 2024. In addition, at its time of its preparation, the agenda of this meeting was similarly disseminated on Friday, September 19th, 2025 at 5:40 p.m. to the mayor, municipal council, business administrator, corporation council, the newspapers, and posted on the city's website, so I can certify as to our total compliance with the Sunshine Law. Council President, I'm going to turn it over to you.
Afternoon. First Director, Director Kears.
Good afternoon, President Waterman, members of the council. I have 2 items before you today. First one is item 1010-25-615. The resolution will authorize the sale of 28 motor vehicles and various motor vehicle equipment through the publicsurplus.com public online auction, which are no longer needed for public use. Second item is 1011-25-616. Resolution will authorize the public sale of 73 motor vehicles through the publicsurplus.com public online auction, no longer needed for public use.
Thank you.
Asia.
Want to record Councilperson Solomon present at 4:04 p.m. So we now have 6 council members present. Go ahead, Director.
Hello, everyone. Good afternoon. Deja Anderson, Director of the Division of Community Development. I have agenda item 10.15. That's resolution 25-620. And this is a resolution to authorize the municipal council to authorize amendments and forgive the notes made by the Fairmount Hotel to the city of Jersey City and authorize the discharges of the mortgage for the acquisitions and renovation of 2595 Kennedy Boulevard in Jersey City, also known as the Fairmount Hotel. I had come before council last week with some information, but I think there was some slight misinformation and miscommunication about this project, what this project is slated to provide to the community. And I think the developer also needed to answer some questions and concerns about the relocation of the senior citizens, because this is affordable housing for seniors in Ward B. So this property received about 3 different funding streams, totaling in the ballpark of slightly over $1 million for work done in the property, starting with November 28th of 1994, and then subsequent years where they received this funding. They have met their restricted period and their obligation for the funding that they've already received from the city. Those restricted period ended in November of 2024, okay? So where we're at now, how these documents were written up is that there is a balloon repayment due at the end of this restricted period. That repayment due to the city is in the amount of about $20 million, okay? So typically for community development block grant, we do not set those up as interest-bearing loans. We're not a financial institution and we don't have the ability to take those payments in on a monthly basis. So if anything like this was written into our contracts, it's almost always written in as a balloon payment at the end of the period. What the intent of writing something like that is to give the city and the municipal council a negotiating position with the property owner for us to be able to lock them into an additional or extended period of affordability. This property owner did come to the city of Jersey City in 2022 and did request community development block funds to do the said repairs to the property. Per community development block grant, they were not eligible for these fundings. Being a for-profit entity, those funds are for nonprofits or for the municipality to use on their own. So with that being said, DCD advised the property owner to go out and find another source of funding to do the repairs, which they did. They made application with the NJHMFA to do these repairs to the buildings for a pool of funding that was specifically set aside for buildings whose affordable restrictions had recently terminated or were nearing a termination period so that we can continue to preserve affordable housing here in the city. Are there any questions that you have for me and DCD in reference to this? And I believe I have Jerry McCann here who can also additionally answer some questions on behalf of the ownership entity.
Didn't they threaten to throw people out, or they're moving people out?
So not to my knowledge, and I wasn't privy to any conversations had like that with the residents. I do know that there had been some community members who raised issues about that. What I did provide or get receipt of was a copy of the relocation plan that they did offer to all of the residents. None of those required any of the seniors to go to see Caucus. That's been something that's been floated around. But I think Jerry here can speak a little bit more specifically to what information were shared with the seniors in the building. I know that they had about 8 to 10 vacant units inside of the building where they were willing to move some seniors in and then go repair their individual units and then move them back. Those that decided that they didn't want to move into those units were also provided a list of available apartments within Jersey City and Union City. And Bayonne. So within Jersey City and Bayonne for the period while the rehab work are going to be done in their units. So there's a portion of the work that needs to happen in each unit. That's upgrade to the kitchens, upgrade to the bathrooms, and fixing all of the windows. And then there's common space work that needs to be done. And there's a dire need to repoint all of the bricks to the building. This is a historic site, so it's going to take a lot of work to make sure we fix that all in. But I definitely want them to be able to answer some questions that you have.
Hi, well, my name is actually Jim McCann from the law firm of Connell Foley on behalf of the owner of the Fairmont Hotel. I can answer any questions you have about the proposal before you today. I can assure you that, first of all, let me say this. I've represented this property owner for 25 years. They've successfully operated a senior citizen, low-income housing project in the city of Jersey City for over 25 years. I was involved in the original development of this project. And I don't think it's ever come before today with any complaints about how the residents have been treated. There are some people who've lived there for 20 years who are very happy living there. And they'll continue to be happy because there is no desire, there's no plan, there's no indication that any of them are going to be permanently removed from residents in this project. Also, I'll put on the record that their rent is not going to be increased after the rehabilitation is done and they go back into their apartment. It's necessary to temporarily relocate them because you can't renovate the inside of their apartment with them there. So what the developer has done, what the owner of the project has done is offer a relocation plan, which involves 3 things. The first thing is that there are approximately 8 vacant apartments in the property right now, and they're vacant because the owner knew in the past 8 months that they wanted to do this renovation, so they kept some apartments vacant. So if a resident chooses, while their apartment is being renovated, they can temporarily relocate to another vacant unit in the building. They'll pay the exact same rent that they're paying for the unit that they live in permanently, no increase, no matter if they move into a bigger unit. And then when their unit is done being renovated, they'll move right back to their old unit, which will now be renovated. The second option is they can relocate by moving in with family. And if they choose to move in with their family, there will be no rent charged to them during the time that they're not living in the building. They can save some money if they can live with a relative for free. So there won't be any rent charge to somebody who moves off the premises. The third option is the owner does have access to a market rate luxury building in Bayonne that's recently been developed in the past 10 years. He has access to certain units there. He will relocate the tenants to that building if they can move to Bayonne. If they want to move to Bayonne, they will not be forced to move to Bayonne. And they can live in a market rate building paying the same exact rent that they pay for their apartment right now. I believe that that's been sent to a number of council people by email, but if it hasn't, I'm putting it on the record for the purposes of tonight, that's the relocation plan. The other thing is this isn't, you don't have to take our word for it because the relocation plan is overseen also by the NJHMFA that's providing some of the financing for the renovation of this building. And as you know, that's a state agency. They've regulated this project for 30 years because it's been under their jurisdiction. And they have some very strict relocation rules, which the relocation plan I just explained to you complies with. So there will be some oversight besides the city of Jersey City, which you're welcome to provide oversight to, but there will also be some oversight from the state regarding the relocation and the renovation.
Questions?
Yes.
After going through, oh my God, about 3 of these in this term here, one I want to ask, have you guys done meetings with the tenants already? And have you expressed those 3 different options to them? And how do you plan to execute them?
Absolutely. My client has met with many of the residents, and many of the residents are fully now they understand the relocation plan and they're in support of it. I spoke to Councilwoman Hewlings today, who it's in her ward, and she's gotten a number of emails from tenants that live in the building now in support of the renovation plan and the relocation plan. I don't want to put words in her mouth, but I did speak to her earlier today.
Okay, so you guys have met with the tenants. Now,
Yes.
as it relates to the time allocated for renovation, how long are you prefiguring each apartment would take?
I think it's probably around 3 months, subject to, like, the building's 30 years old. So there's a certain amount of work that has to be done. They don't know how much certain things have deteriorated and things, but I think the overall renovation of the entire building is going to take a year. That would include the apartments being renovated, the common areas, and most importantly, the elevators, which are very old and need to be replaced. So the overall renovation is going to take a year, but that doesn't mean that every tenant is going to be displaced from their apartment for a year. I could get you more information on the estimated time for each resident before Wednesday's vote on this.
Okay, yeah, because that's my major concern. Because like I said, going through these things, I mean, everyone have came in under 3 months. They're doing Gateway East 1 over now, which haven't been renovated since its inception, I believe. But I do understand the lengthiness as it relates to the actual elevators. But my primary concern was the dwellings. How long does it take for the dwellings, and that clear communication have been with the tenants and they know what the expectations are? Because the last thing we want to happen is this renovation take place and then everyone's like, oh, I thought this, I thought that, I thought this. And like I said, just going through these rads and these renovations, it's I don't know, it's just been a mess, and I don't know whose part have it been on. I just know that there's been major, in fact, I'm not even gonna say that, but it's been a lot of problems with these renovations as of late.
All right, I will go back to the developer and make sure that I relay your concern that the residents be treated properly during the renovation and that the renovation of each apartment be done as expeditiously as possible. I know that's the goal anyway, but I'll relay the concern for sure.
Questions?
Yeah, McCann, I don't want to disagree with you, but
Mm-hmm.
last council meeting, there were a couple of people sitting right up front here that were complaining very much so about the building and the way they were being treated. I mean, I know you're the lawyer representing them, and you're not going to say anything bad about them, but they did.
So I do know that happened. I wasn't representing the client at the time, but my clients talked to those folks. I don't know if he's changed their mind or not, but I could tell you it's only less than a handful of people who are upset with the renovation plan and the relocation plan. My understanding is the vast majority of the people that live in this building now understand and are in support of it.
Jim, let me ask you a question because I was at the meeting. Part of the conversation was that they had to move a floor at a time. That was part of the conversation, and that was a concern because if everyone didn't agree, then they couldn't do that project on that floor at the time because of the piping. It's something with the piping in that building on one side.
Right, it might be a strip of apartments
Right.
at a time, right?
Right.
I understand. Look, I understand the problem. The thing is, in order to renovate the building,
Uh-huh.
you know, you have to, that it has to be done in an efficient way in order to get it done quickly. So that may very well be the case that they have to vacate certain apartments at the same time in order to efficiently perform the renovation of those apartments and the common areas.
And another concern was, okay, where would their things be stored at? Because you're dealing with seniors and they really, can't pack up everything because of their age and, the discomfort of it. So is the developer willing to pay their storage and pack it and store it, really? I was there. I was at the meeting.
Okay, I
Okay.
will check. I may even be able to check, be able
Okay.
to check on some of these questions before this meeting ends.
Okay.
But I will check on whether or not, I know the owner has a staff and I'm sure he'd be
Mhm.
willing to have the staff based on my prior experience, work with these folks to help store their belongings, but I'll check that
Right.
out for you.
Please check on that because they was concerned about that. I know.
Okay.
Jim, I'm going to read the relocation plan. I mean, we just got it, I think, so recently, and thank you, Director Anderson, for helping us answer questions. I think my big question is, what's written in the plan at first glance looks all right. What happens if the developer doesn't follow through on the plan? What's the mechanism? Who enforces it? And what's the, potential consequence for not living by what's being committed to?
I'll have to check the financing documents to answer that question for you.
Sure, yeah, if you could just do that in the next 24 hours, 'cause that's the important thing on our end, or at least in my experience, has been, sometimes we've gotten good plans, but then, they're the show to get the vote. And then once the vote happens, then the folks think they can kind of not abide by them. So it just, on our end, would be very important to just understand that process.
Acknowledged.
Thank you.
All right.
Tyrone?
Just want to record Councilperson Gilmore present at 4:11 and Councilperson Saleh at 4:14. So we now have 8 council members present.
Good afternoon, Council. Director Chiron Richardson of Housing Preservation. I'm coming before you today for pretty much 3 items. Item 3.5, item 4.4, and item 4.5. Now, I will say that I'm happy to report that last week, concerning these resolutions, had a meeting with Isaac from Councilman Solomon's office, because my concern was that when I saw anything that was going to need to be enforced, the concern is are we able to enforce it? And so because when these resolutions were submitted with the first reading, I hadn't really had a conversation with anybody. And so I didn't want to have something pass just for the people to be promised something that couldn't be enforced because we didn't have the mechanisms to enforce it. After the conversation, it appeared that item 4.5 and item 3.5 would be something that would be more dealt with the Office of Code Compliance. And I know the prosecutor is here, and so he can speak more about that. Oh, is that better?
Yeah.
Okay. And so I know the prosecutor is here, so I believe he can speak more to item 4.5 and item 3.5. Again, my concern was that when I saw something that affected my department, I wanted to make sure that it didn't add more burden to my department, because as you guys have heard, throughout the city, I understand that there's a staffing issue, but just to put some understanding to that, one of the things our office does in order to help enforce these ordinances is that we review landlord registrations. When I first got to the office, 5 people were reviewing about 700 registrations a year. That number has moved up to 1,700, but now we've lost 3 staff members. When it came to the short-term rentals, after the Airbnb decided to enforce it more, the numbers that we had last year doubled in less than 1 year, and I only have 2 staff people doing that. So the concern was that before we pass something, please have the conversation with the offices so that we can ensure that when the people are now wanting to be enforced, we can assure that it's going to be enforced, because I had somebody reached out to me already and then their property was not rent control. Well, that's a whole nother issue that had we talked about it prior to, you don't have somebody who's out there, again, hoping, because they're looking at these meetings, they're coming to these meetings and they're hearing this is going to be done. But if the person who has to do it is not consulted, unfortunately, the tenants suffer. And so I just wanted to make sure that we are having that dialogue. But I'm glad to say that Councilman Solomon actually had Isaac come to our office. And so after having the conversation, as of right now, it appears that it's not going to add undue burden upon our office. It's just some things that we need to clarify. But again, I just wanted to be sure that moving forward, we can have the conversation, because again, I don't want people to expect something that we can't provide simply because we don't have the staff.
So Director, then I have a question.
I have an answer.
So with these amendments and providing that this passes,
Yes.
what changes do you have?
So on my end so far, it just seems like it's just a matter of clarifying some things on my end. Now, the prosecutor, when it comes to the enforcement, I think he has an enforcement component that we will not necessarily have to enforce from housing preservation. Again, I want to let the prosecutor speak for himself. But on our end, when we talked to the councilman's aide, it just seemed like Chapter 260, there was some clarification things that's pretty much we're going to submit about 3 items that you guys would have to look at and amend, but they were not items that would actually wreck the whole office. And so again, these are 3 small clarification things I think that will help move this along on my office end.
Your office won't be required to do enforcement. It's not
No.
your office.
No.
Okay. That's in the ordinance.
Right. So I think when you look at the enforcement, I believe it's 4.5 and 3.5 deals more with the enforcement aspect. My office is going to be dealing with clarifying some things in Chapter 260. And then, and so those things are things that we're going to be able to do out front. And then, of course, we're still talking about if some more enforcement issues arise, we just want to be sure that we can let the council know this is what you guys are asking. This is exactly what we can do. Because when the constituents talk to you, we want you to have the confidence of knowing that what you told them we can do. But as of right now, on the enforcement side, it's not interfering with my office. Just some clarification points.
Not your office. Okay.
Is this submitted to the law department for review, all of these? And does the law department have any information or opinion or on these ordinances?
It does go through. We changed it to make sure everything went through from the council people through the law department. We really do just check it for form if sometimes we're not involved in the underlying substance of drafting it. I know there were conversations between Isaac and John McKinney about this, and he gave his opinion. If you want our opinion in writing, we can do that as well. I also did have a conversation with Director Richardson after it came up, and we were all trying to figure out what would be put on what department. And like you said, one of them was really, we were just shifting some language around and clarifying something, and it wouldn't add a burden because his office was already doing something that was included in it. So unfortunately, we had those conversations after but we can give you our opinion on it.
We'd love a
We do-
written
We
opinion.
do look
Please.
And
beforehand.
then if I may, that was another suggestion that, my suggestion was that in this case, and I can only speak for this case with that, a conversation between my office, the prosecutor, and the law department, because again, I think that would tie everything up and it leaves everything pretty clear for everybody to understand what can be done.
I know the prosecutor is here too. Prosecutor, would you come up and explain this on, I guess, your enforcement end? Will you guys be able to enforce it, or, what is the situation here? Because the director's here too. I want you guys both up here so we can get clarity.
Good evening, Council President, members
Good
of
evening.
council.
Yes.
I'm here to speak on agenda item 4.5.
Mhm.
More specifically, the single complaint sufficiency. And my understanding is that agenda item, 3.5 replaces 4.5. I think some of the questions that have been, or statements that have been put in front of the council the past few months have afforded me the opportunity to enlighten people about some of the challenges in municipal court. There are certainly challenges that I've been having for many years as municipal prosecutor, and I'm pleased that there's now an audience for me to air those concerns. One of the things that I've explained, and I've had some positive conversations with the Portside residents in the past few weeks, is that a summons by itself is not a fine. A summons is not a fine until it's either pled to or until a judge finds them guilty beyond a reasonable doubt. Many states treat code summonses as civil enforcement matters. New Jersey does not. It treats it as a quasi-criminal offense. And the burden of proof that my assistant prosecutors have in domestic violence cases, in assault cases, in theft cases, is the same burden of proof that we need to prove on each and every code summons. And secondly, another issue in line with that is that not every municipal court judge acts in conformity with one another, and it's very frustrating. What ordinance number 3.5 does is clarifies that a violation for which the maximum fine is $2,000 is a per day violation. That is something that state enabling statute makes clear, and it's something that our state Supreme Court clarified in 1999, that one summons can get you $2,000 a day. We do nonetheless have judges in municipal court that require multiple summonses for multiple days. Agenda item 3.5, ordinance 25-105, will make clear that one summons is $2,000 a day. More so, some judges require a separate trial on each and every single summons. So not one trial in which there's a 10, 20, 100 summonses happening and one opening argument and witnesses, one closing. Some judges actually require a separate trial on each summons. And you can imagine the frustration that has on getting through code enforcement quickly. Just to sort of like clarify, I believe it was mentioned to the council that all the ordinances against Portside Towers are in pretrial conference phase. And we're back for a pretrial conference on October 23rd. And this is the court calendar for October 23rd. It's 14 pages with 13 summonses each. So it's over 150 summonses, but that's only for 3 violations. No uniform security, no superintendent on site at 100 Warren, and failure to register their landlord statement. But yet we have over 150 summonses, because when those summonses are written, we don't know what judge they're going to be assigned to. So we write the summons every day to cover ourselves and emphasize to the offender that these are per day violations. If we had had this clarifying language earlier, these would be 3 summonses. Only 3 summonses that I would need to get in one of, I can harmonize if you want. Only 3 summonses, but instead it took us almost 8 weeks to get the court to put these 150 summonses before one judge. So when the Portside residents speak about the frustration of the timing, one of the first things I said to them when I spoke to the president of the association last week was, a lot of their frustration is my frustration. And let me just parse that out because I want it to be clear. When a summons comes into the municipal court on a criminal matter or a traffic matter, data entry takes that defendant's name and puts it in the computer to see what else they have open in the court to make sure that those subsequent summonses get in front of the same judge and the same assistant prosecutors. The municipal court does not do that for code violators. So you have a situation where if it's like Portside, where it's the same issue being written over multiple days, or it's one of my task force inspections where zoning is there, fire is there, code compliance is there, housing preservation is there. If those 4 inspectors turn in their summonses on different days, those could conceivably end up in 4 different courtrooms. So what's so important about this ordinance is, one, it's going to cut down on the number of summonses being written, but it's still going to emphasize that these are per day violations. But 2, I bring up the second issue because there are a lot of important questions to ask about the municipal court. I say with complete confidence, the work that my office has done in the past 7 years has brought us light years of where we were when I started. And we're at a point now where my assistant prosecutors and my support staff, we are firing on all cylinders. And if it doesn't look apparent to the folks at Portside, or it doesn't look apparent to the council, that's the opportunity to ask me questions, because there are frustrations. We are hitting walls such as this and the scheduling, and it taking 8 weeks to get Portside in front of one judge. And I'm happy to talk about those things. So I'm happy that I have a conversation with the Portside residents. I want to give thanks to Councilman Solomon for listening to my concerns and withdrawing 4.5 and instead introducing 3.5. To all of the members of council, I encourage you to reach out to me and ask questions when you have questions about enforcement and municipal prosecutions. And I just can't emphasize enough how much of an impact this single summons sufficiency ordinance will have. So I strongly encourage that you pass it. And I did just want to note, I'm just joined by Deputy Chief Municipal Prosecutor Vishnu Kamaraj and Code Compliance Director Joe Barrow. And with that, I'll take any questions the council has.
Yes. Hey, Jake, just help us understand, like, how does this process look in totality? Someone calls about an infraction or a violation, said department go out there, they write the infraction, what is the steps in those processes?
Well, so it depends on what the violation is. It also depends who they're calling. In theory, they're calling the residents responsive,
Yes.
and then it's being channeled appropriately. However, code compliance receives direct constituent concerns. My office, the prosecutor at jcnj.org mailbox, is heavily trafficked by the public, which we're pleased with, because we want the public interacting with the municipal prosecutor's office. But my office prosecutes on behalf of 17 different agencies, a combination of code and law enforcement. And some of them, councilmen, require a notice of violation in which they're given a period to abate. And then if they don't abate, it goes to summons, but some of those can go right to summons. The process then is, once it's on summons, it goes to scheduling in the municipal court. That is not under me. Sometimes folks think I oversee the municipal court. I don't. I'm just one party in front of the municipal court. And I've, over the years, raised concerns in the criminal context, in the traffic context, and the code context of how long it takes for a first appearance. I've even gone to the county assignment judge a few years ago with those concerns, and we've seen improvement, but eventually we slide back. And we actually see sometimes between 6 to 8 weeks between issuance of a summons and a first appearance. And then typical adjournments, because I think another thing that folks think that when you go to municipal court, you're there for a trial. You're not. You're there for a pretrial conference. And, when I talk about the quasi-criminal burden of proof, that means that the landlord that's accused with putting her trash out early has all the same constitutional rights as the domestic violence defendant. And trust me, as we get tougher in court on code enforcement, they're hiring better and better lawyers, and they're asserting all their discovery rights. So you're probably looking at, on your more complex code enforcement, 2 to 3 status conferences before a plea or a trial. And the court, again, I'm not in charge of scheduling, typically adjourns matters for 4 weeks in between each pretrial conference. I often say when I was a defense attorney at the county, I resolved homicides in less time than it takes for us to resolve code enforcement in the municipal court. So I think there's a light to be shined on the scheduling in the municipal court. But again, I hope that answers your question, that I'm trying to paint the picture that it's not a summons and a hearing and a fine. There's a lot of steps in between. And I've got great lawyers and great support staff. We've expanded the office since 2018. But it does not happen as quickly as I think some folks perceive. And I just want to be clear, there are states that do summonses on a civil enforcement mechanism where you get the summons, you go to court, and you're there to pay a fine or dispute it. And that's just not New Jersey. New Jersey treats these things as quasi-criminal.
You alluded to the fact that you, the timing has increased with regards to the summonses. Do you have data on how many summonses you're doing relative to years past? Do you have any data on, like, you know, what's being enforced or what the emphasis is on?
I actually do. So I have data on the Office of Code Compliance. So far this year, the Office of Code Compliance has written 13,681 summonses. In 2024, the Office of Code Compliance wrote 18,299 summonses. In 2023, they wrote 18,526 summonses. In 2021, sanitation, commerce, and housing code enforcement were combined into the Office of Code Compliance. We used to have 3 separate sets of inspectors that went out and did property maintenance and licensure. Before we combined those 3 divisions into the Office of Code Compliance, their totals combined were about 3,300 summonses in 2018, about 4,700 summonses in 2019, and about 4,500 summonses in 2020. So the Office of Code Compliance is more than quadrupling the work of the 3 offices that made them, or that came together to form them.
And also with regards to which judge hears, you know, the summonses, is it the discretion of the judge to have a separate trial for each summons? Or is it that just the way the case filing system is?
No, there's at least one judge that believes each summons should be its own trial with its own opening, its own state's case, its own case in chief. And that is what it is. But I think, you know, I can't change. I mean, I guess I could do an interlocutory appeal on such a small issue, but it's one judge. And then you don't know what ruling you're going to get. If we were to appeal that, we could create bad law that judge is right. And then we're stuck with that across the board. Single complaint sufficiency will cut down on that, because we'll be able to just do the one summons for the multi-day violation moving forward, and then argue at sentencing that these are per day violations. And I actually think for the summonses that are pending, you know, we have to prosecute these the way the law was when the summonses were written. But I think it's going to clarify to the judges what the law always was, because the councilman's office is just codifying what the Supreme Court clarified with this exact issue in 1999.
So, Jake, with regards to the number you said, these are the number of citations that was just issued. Do we have any data that speaks to the amount that were dismissed, that went to trial and the perpetrator was convicted, or that went to trial and it was thrown out, or that was thrown out?
Councilman, I have, we do track dispositions, and we're at about, we've gone up. So we track the disposition of property maintenance fines. In 2023, we were at about 800,000. This year, year to date, we're at about 1.2 million. But there's also this other, I think, misperception. Nothing is dismissed without a reason stated on the record. And I think Because ordinances are quasi-criminal, we plea bargain most of them. And that's just a reality. And that's a reality across the United States in any prosecutor's office of any level. So, let's take like the lowest hanging fruit, which is like the trash summonses. We might have trash bins brought out early, and we're going to have a summons for trash out at the wrong time, trash for more than 5 inches above the rim, and trash creating a nuisance. If I can get $500, $750 on one of those summonses, rather than taking them to trial, I can't take every defendant to trial. So those two will be dismissed, and we're going to get a substantial fine on the third one. And that's just the reality of criminal and traffic and code prosecutions in any office across the United States, not just here. So I cannot imagine a situation in which there would be a dismissal of all charges unless there's unless there's like a problem with the summons, right? For example, I mean, Portside, last time that we were in court, some tickets were pled to because those were the only tickets that didn't fall into these three categories. And there were a few dismissals. Some were complaints that were written under the wrong ordinance. I couldn't prosecute them. I can't prosecute something written under the wrong ordinance, but I still have that violation written the right way. So I didn't lose anything by dismissing it. So I just think that this perception that tickets are thrown out or dismissed is an unfair perception.
Okay, I mean, be that as it may, I just think that, I mean, I get the challenges and complexities of the municipal court as a whole. But for me, when I'm looking at legislation as it relates to violation, is intent to deter behavior. And if we constantly have the same individual or individuals or entities committing the same offense, and let's say, I don't know, if you give Director Richardson and his establishment 27 tickets and he's able to go to court and plead to 4 violations, and then next year he do it again, and then the following year he do it again. I guess my point in asking the questions of the differentiation in numbers, more specifically, I'm trying to figure out if there's repeat offenders constantly being able to receive plea bargains, and if so, what are some of the reasons? Do we have to write the violations better? Is it a matter of us not having the capacity to actually prosecute all of the citations? Like, I'm just trying to understand exactly what is going on.
Sure. So I do want to say that we do catch repeat violators. Again, code compliance is one of 17 offices that send me summonses for prosecution, but they themselves flag repeat offender, and they'll write it on the summonses sometimes. But the other thing, COVID forced, well, it was something I wanted to do. I wanted my office to go digital. When I became municipal prosecutor, my office did not have their own files. They would sit in court, and this is common in municipal courts across the state. They would borrow the judge's file and work off that. And then when the session was done, they'd hand it back up. It's completely inappropriate, but it's common practice in municipal courts across this state. COVID, when we went virtual, there was no way to share files. So we've now gone to virtual file management. So my office has a folder for every address that's ever been written a summons. We have case notes. Sometimes I sit in and cover for my prosecutors in the code enforcement court. I'll see who's in the waiting room. I'll look up the address. I'll go to the case notes. I'll have such detailed notes from some of my assistant prosecutors that, like, I go into that conference ready to get the bigger fine. I know what their excuses are going to be. Some of my APs keep such meticulous notes that I'm able to stay 10 feet ahead of these people because they have every excuse in the world, these landlords. So we are able to flag them. Again, my point is not to sit here and say everything is perfect. I think if from sitting on the council, it looks like there's enforcement challenges, I think the bigger issue is our failures to appear, our properties. In fact, Councilman, your office, your aide, Ms. Walker, emailed about an address today, and she had indicated that it was put into C-Click's fix in July. And I looked, and code compliance went in early August or late July and wrote the summons,
Yes.
the whole 9 yards. And so I said, I'm going to go in and I guarantee now I can understand we're sitting where you sit. That's a dismissal or that's his office being weak. I go into the court computer and I look and it's a failure to appear. Nobody ever showed up. So I take the summons info. In fact, the inspector was here a moment ago. And he wrote off the tax plate. And I take my code enforcement liaison, and we have a deeper research system than the tax plate. He spends 15 minutes, and we finally wind down through 3 different LLC shell companies, and we finally get a human being. So the tax plate, and this is not a fault of, I'm not putting this on the tax assessor or the tax collector, but these LLCs make it nearly impossible to bring a human being to court. And as long as they know that, and as long as that these summonses go into space, that's why there's frustration. So those summonses are going to be rewritten because we now believe we have better information on a registered agent. Because I'll tell you, most of these LLCs ignore the summonses until they see a human being's name written as a care of. So I now have a new registered agent's name, and those will be written shortly. Now, look, I don't expect you to be gracious that 8 weeks later I'm still uncovering this, but that's the reality of LLC-owned property. Senator Stack has a bill in the legislature right now to make sure that our state requires that there's human beings behind LLCs. The state does not do that right now. You could go on Treasury and you could look up LLC, registered agent, LLC, registered agent, LLC, and you could go down a wormhole of LLCs until you get to human being. And that bill has passed the state Senate. It's currently in the state legislature, and I hope it gets put into law because I lay that at the state's feet, that it's just impossible to tell who the human beings are behind some of these investment properties.
Thank you. Thank
I
you.
had-
I appreciate it. I appreciate it. You got one more question?
I think Yusuf.
Yeah.
One more.
Oh, well, I had 2 more, but what percentage of the cases that you deal with do eventually go to trial?
I don't know that I could quantify it, but I do have my currently have about 30 cases scheduled for trial between now and December 19th, but that contemplates code, traffic, and criminal. I'd have to break this out specifically. I think I would stick with standard 20 to 10% go to trial, which is, I think, kind of a common statistic across all prosecutors' offices.
And what happens eventually when, you go to trial, there's a judgment made and they don't pay? Like, let's say.
If you were a plant, you couldn't have done better, Councilman.
We did not collaborate on any of this. I have this. We're going to invite you to our hearing soon too, by the way.
Somebody recently said to me, why don't you write a letter of everything your office has done since 2018? And I said, there's not enough paper in Jersey City for me to write that letter. In the old days, before I was municipal prosecutor, that judgment went nowhere. And so I have to give thanks to my friends at the law department, Phil Edelman. We coordinated to now have a streamlined process, and I believe it's the paralegal Tuesday Cardwell. I hope that's not weird, I'm saying her name, but she does very good work. We now docket those judgments. So we do trials in absentia against LLCs, which is people that don't show up. We do default judgments against people who stop showing up. We send those right up to the law department to be docketed as liens. So no, it doesn't just float in space. It becomes a docketed judgment. And again, we can't do that without the law department's help, and they're fantastic on getting that done.
Okay, thank you.
Hey, thank you, man.
Thank you.
Seriously.
Thank you. We appreciate you.
And just one quick just logistical point, and for the clerk, and we thank the prosecutor for working very effectively over the last 2 weeks and for reaching out. It would just mean that we would ask the council to defeat 4.5 when we get to 4.5, because 3.5 replaces it.
Yeah, so once we introduce the ordinance, when we get to that second reading, I would just need a motion from the council to go right to defeat instead of holding a public hearing on something that is not going to get adopted.
Thank you. Oh,
Oh,
go ahead.
Just add one other thing. First of all, I want to say I didn't appreciate Councilman Gilmore painting me out to be a criminal in my department. Get the point across. I just don't know what that was about. But to Councilman Rivera, I just wanted to clarify again what you asked me about 4.4. When it comes to clarifying what was asked as it relates to how does it affect my office. One of the issues that have come up is that when it comes to registering your property, though we basically only enforce rent control properties, what's not clear is that even though your property may not be under rent control, you still have to register. So that's one of the things we want to clarify, to let every person know that whether or not you are exempt or unexempt, you still have to register your property. So something like that, since we're already doing registrations, it doesn't add any undue burden on my department, division, but it also clarifies for those bad actors, or maybe good actors, maybe not know, but either way, they understand that when we want a registration, you can't say we're exempt. You still have to register your property. So that's an example of something that we're already doing, but we want to clarify that it must be done.
I appreciate that. I think if the prosecutor would have spoken before you, I would have never asked you that question. You know, he gave us a whole boatload of information that we've probably been asking for several years now, you know, and you know, I'm glad that, you know, there's some clarity, you know, with the port side people. You know, they've been here day in and day out. We wore it, you wore it, you know, and I'm glad that you know, that there's clarity, and that's important.
Expect an invite from the committee, by the way.
Thank you.
Thank you.
And
Thank you.
council members, if I could just end it with, I know Councilman Slay asked me before, just because something is legally permissible does not necessarily mean it's advisable, which is why we always, you know, tell the councils to speak to the departments and divisions that are going to enforce it. Because something could be, yeah, sure, we can do that, but these directors know practically how it works day to day, and they have the best knowledge behind it. So that's why sometimes when we give you a confidential memo, we say you might want to ask somebody else as well, because they might have the inside baseball for you.
That's true. Thank you. Tanya.
Good afternoon, Council. Tanya and I are here on two items. The first being Agenda Item 3.6, Ordinance 25-106, an ordinance of the Municipal Council of the City of Jersey City referring and adopting amendments to the Bright Street redevelopment plan, allowed accessory uses in Zone 3 residential infill. This is coming before the council in the form of a first reading ordinance, as opposed to directing the planning board to study an amendment. Therefore, and because of its location, should this be introduced, it would go to the Historic Preservation Commission because it's partially in a historic district, then to planning board, and then return to city council in the form of a second reading ordinance. The ordinance before you is attached to this document. It is one page, on page 4 if you have this ordinance printed out on its own. The top, it says Zone 3 residential infill, paragraph C, and the yellow highlighted section is the scope of this amendment. It is simply looking to add the accessory uses for retail sales, retail services, and cafes for businesses that are less than 2,000 square feet. And that is the scope of this ordinance. Are there any questions?
So what's the geographic scope of the Bright Street redevelopment plan?
Yeah, it is, I think it's just 2 blocks and half of one city block. So it's just two sides of the street on Bright Street between Barrow and where Bright Street ends at Grove. So it is a small area. There is, it's largely built out, and it's in a historic district. So anything that would happen here that would perhaps include something as an outcome of this amendment would still have to go to Historic Preservation Commission. And there is existing space that is on the ground floor that could potentially be used for an accessory use here. And since this isn't mostly in a flood zone, that ground floor cannot be habitable if rehab to a certain extent.
All right, thank you.
All right, just so there's no confusion, Matt's not up here anymore. It's me, Tanya. I know we get confused a lot. We're different colors today, just so you all know. But I am here at the request of the council president to clarify issues on an ordinance that you tabled. I believe it's 11.1, but the ordinance is 25086, and that's the Journal Square amendment.
That's 11.11.
11.11? Yeah. And so I don't know how you want to proceed, if you want me to explain or you have questions. I would assume that if you have questions, that might be the easier way to do this.
So.
Yeah, you saw.
What?
This is the.
You go. Count.
No, I just want to make.
Councilman Gilmore,
no, I
let go.
just want to make sure which
You go.
one. This is the one we talked about that we tabled from last week, right? That's why I was.
Now you go first. My bald brother from another mother.
This, but
I guess-
this one, just so we're clear, councilperson, this one is the amendments on the Journal Square 2060 redevelopment plan.
Yes, and if I remember this correctly, the issue was some areas within the vicinity being excluded from the zone. So
Right.
that's my question was essentially centered around, because for me, I just couldn't understand that if parcels were within the scope of the zone, why weren't those parcels included in the 2060?
So if I'm going to answer, it's going to take a minute. I'm just going to rewind slightly. When we did the initial community meeting, we came to the table based on the resolution from Councilman Bogiano's office, and we presented an entire Zone 4 mandatory affordable housing amendment. We also had additional amendments that the county had requested, and even the city for additional parking, even the community. So we had like kind of a parking overlay. Then we had the Arts Walk overlay. Parking, and then we were adding 3,000 Kennedy, which is where the Dollar General is. That community meeting, the feedback we got was that they were not ready, the community and neither the councilman's office, to move forward with Zone 4 mandatory affordable. Zone 3 already has the mandatory affordable. So we made the decision to basically separate the two. So there is nothing in here that deals with the Zone 4 mandatory affordable housing overlay. We have separated it out and we will potentially move it forward in the future after working with the councilman's office. So the only thing, if you're seeing a map that has some lines on it, that's a map change to correct split zones. So there are some lots that have developments already, and they're split zoned. And so that is really just kind of correcting that development so that it's all the same zone. They were already going to be zoned. They were already being developed as Zone 3. So there is nothing in here that's excluding some and including some. We've separated out that affordable housing component completely from this one.
Okay. So I guess my next question is, as it relates to the type of dwellings can be built in 3 and 4, what are the difference?
So again, really, nothing is happening in 4 in this amendment unless it was included in the parking bonus. We're really not doing anything to 3. We're not really changing anything either, unless it was the parking bonus again. The only thing I'd say that is unique is the Dollar General. Now, the Dollar General was in a different redevelopment plan, the St. John's redevelopment plan with all the buildings that are behind it. There is no more zoning for that site. So that site cannot be redeveloped with anything. So the really only logical conclusion was to include it in the Journal Square redevelopment plan. If you look at the map, it's a really weird kind of cutout. So we've included it in and included it as Zone 3, which is what's around it across the street and et cetera. So that's really I don't know if that's what's kind of throwing everybody off, but that wasn't Zone 4. That was St. John's redevelopment plan.
Why was the affordable housing not included?
Are you asking, Matt said, I didn't answer.
Oh, why wasn't the affordable housing included in this amendment?
Because the feedback that we got from the council person's office and the community was that they were not ready.
They don't want affordable housing up there.
Not that they don't want affordable housing, they didn't want the rezoning.
What?
So
That's why I'm trying to figure out because how do you like,
Gilmore, I mean, like.
Just step back one thing. We're talking about 2 lots that paused this ordinance, as opposed to several city blocks that are zone 4. So we had an alternate mandatory affordable housing language for all of zone 4,
Right.
which was much smaller than the request that's being made before council. And the planning board heard this presentation, a motion was made to incorporate that language, and it wasn't seconded. That's in the resolution for you tied to this ordinance. So it came to planning board, it was presented, motion wasn't seconded, motion that did not include that language was made, seconded, and
remember that.
passed. That's what's before council.
What if we disagree with the planning board and let's say the council says like, we'd like to add these parcels, would we send it back to the planning board or would we amend it?
just the parcels that you were talking about, I would say that that's spot zoning and it's arbitrary. Right? Because when we looked at it, we looked at zone 4 across the board and we made a decision that was wholesale. It was based on evidence that we were able to use based on square footage and affordable housing and real numbers. To come up to the table and say 1, 2, 3, 4, these lots I want to be 20 or 50 is arbitrary. Right? And so we called it out immediately. So if you want to pass an affordable housing amendment, you can pass it. I think you can bring it back to not this ordinance, but you can bring back a separate ordinance dealing with just zone 4, but you should do it so it's not arbitrary and it's not benefiting just one developer, despite the story that you're being told.
okay. And initially, you guys met with the community and that was their position. Subsequently, you went to the board. So Rich,
Oh, let's get something straight. Oh, let's get this straight. We had a meeting up there and the people did not want certain areas to have big buildings put where 1 and 2, 3 and 4 family homes are. It has nothing to do with affordable housing. I had an affordable housing bill passed in Journal Square. So I'm tired of hearing people say, you know, we went for it. All new buildings going up in Journal Square have to have affordable housing. Well, the people came, I think there was 142 people signed in, and probably another 20 or 30 came after that didn't sign in, maybe close to 200 people, and they don't want their 1, 2, 3, and 4 family area destroyed like they've destroyed Journal Square. I mean, people looking at these buildings and we're tired of it. And I'm just looking at here, this project for 180 Baldwin Avenue, 2,000 units on Baldwin Avenue. What are you kidding me? Our streets can't handle it, our sewers can't handle it. People are tired of it. We need affordable housing, yes, and we're going to get affordable housing. But let's preserve some of our areas and stop chasing people out of this city.
also that was the intent to try to preserve that area designated for 1s, 2s, to try to keep some type of community type of.
Stop the big buildings from being built next to a 1, 2 family home. It's disgusting. They're chasing people out of this city.
I mean, I understand the argument on both sides. On one side, it's like, oh, we need affordability, let them go as high as they want. I also understand the other side of people wanting to, like, these people have called Jersey City homes for 190 years. So, I mean, I get both sides. But thank you for clearing that up, Director, because I didn't know. That's why I was saying I didn't know that, and that's why you're the expert, and that's why we wanted to ask you.
So we would have to put a resolution forth to look over zone 4, to get, is that what you just said?
Before.
Or,
So again, when the councilman issued a resolution, which was very broad.
Right.
So we took in a ton of issues. It wasn't just the affordable housing. We were asked about the parking. We were asked about Again, 3,000. This is an expansion of the art walk so that we can allow that to also be bigger. There were a lot of things. We added senior housing. We added a lot of rent control. I'm not sure if you read that piece in it. So we added, based on one of the community meetings, there was a big pushback that we were losing rent control buildings. So this ordinance now has language in it that says if you take down rent control, you have to replace it 1-for-1, but not with rent control, with affordable housing at the 30% or below. So the amendment before you today has all of those things except for the zone 4. That's the plain reality of it.
Okay.
So if you wanted to move forward with zone 4, you would have to do a new, I assume, I'm not the legal person, but you would have to do a new resolution or it has to start at the planning board again.
Well, Matt might know the answer. Matt is very sharp.
Yeah, I mean, I think Councilman Vosiano said that he would look at passing another resolution to study that matter further. So staff's prepared to undertake that work.
So in you guys' expert opinion, basically this ordinance right here, it checks several boxes as it relates to the demographic of the parking. There is some affordability in here. I think that was the misperception, is that you're stopping affordability. No, there's still a portion of affordability within 11.11. There's still a mechanism to obtain some affordability.
Oh, there's one that's already in there, and it's already worked. We have an applicant that has come in and utilized it, and we have other applications that have been submitted subsequently that are utilizing it, and presumably they will be moving forward.
All right.
But isn't this project that's going forth, there's a building already there that's 28 stories in the vacant lot. I'm that's why I'm confused with this. Not far, because now we took out the affordability here, but not too far is. a
For the
building.
site that you're talking about, those buildings got the 20 stories because they built the homestead extension. So that was one of the initial amendments from like 2017, that if they built the homestead extension, they can get up to the 20 stories. There is no affordability component from it because it's that old essentially. And that zoning is actually pretty liberal. And you can see homestead is coming along right now.
I just want to say something. We've had over 20 meetings about the Zone 4 issue, specifically after the first meeting. And you are still working with, and we are still working with planning to address all these concerns, including potentially expanding Zone 3 or Zone 2. And, you know, Tanya, you were at the meeting. The place was mobbed. And people, they were from all over the area of Journal Square, basically, and they've had it. They want affordable housing, but they don't want neighborhoods destroyed anymore.
It's still confusing, believe it or not. It is, because you have a building there that is tall, and this one, the lot that it is exempt can build that height and can give you affordability, but this is not included in this plan. So we would have to do another plan in order for that lot to be included to get affordability.
I don't know how that's not spot zoning.
I
I'll just keep saying it, like, yes, those 20 stories were decided
Yeah.
at that point for zone 3 for the homestead extension. That was a
Right.
very specific bonus. Same thing for the Central Ave. When we were asked to do the mandatory affordable, we did it, I think, very methodically, not including square footage, cost of units, and had our architect work on site for it. And for zone 4, the only thing we estimated was that they needed an additional 10 stories. So in a zone that allows for 6, you're looking at 16, not 20, not something or other.
16, nothing higher than that.
Oh, that was what we were proposing for the zone 4. It also happens to be that zone 4 is not in a high-rise zone, right? For the most part, those are 3, 4, sometimes 5-story buildings. So we were looking for a kind of gradual height decrease as it got further away from the path.
In addition, the mandatory affordable housing language that was once part of this effort, kicked in for lots that were above 30 units and also on properties 9,000 square feet or more. The properties that are part of the amendment before you are two properties that front on different streets, are partially tied but kinked in the back, and on their own are less than 9,000 square feet.
Such
Are
a,
there any other properties that were changed in this plan other than, like, let's say the one that was not included, but were there ones that were included?
So there's ones that were split zoned, development properties that had to have a map change, but there's very few of them. It's on page 13 of at least your ordinance, and you can see really it's just 3 of them. And one of them isn't even a zone, one of them isn't even a zone 3, it's a zone 4.
I guess part of the confusion is because it was once in there, and then I think part of the confusion is because affordability was once in there, but when you went to the community meeting, the people didn't want the affordability, and because they was concerned about their neighborhood, but it could exist. That's the question. It could exist. That's, because it was once there.
Yeah,
People didn't want it.
We can send the language that was once proposed for zone 4
Huh?
that was removed upon public
Right,
input and
Right.
meetings with.
because that's affordability there too.
We could pass that along, but I'm not sure, I don't know if the council needs more explanation on
Okay.
that, because it's not just a map change as what was proposed the other night. It is language that has its own standards and provisions. We can send that along if it's asked of us. We'd be happy to.
Thank you. You could send that. Matt. All right, thanks a lot.
All right, send it or,
Yeah, send it.
okay. Will do.
File.
Good evening, everybody. 2 items for the Finance Department. 10.1, Resolution 25606, authorizing insertion of special items of revenues and appropriations into the calendar 2025 budget. These are just grant awards being set up post-adoption.
You said 10.5, Kyle?
10.1.
There's no questions on that. The next item is 10.17, Resolution 25622. Couple pieces here. These are annual debt service obligations that we have to address. $124 million in bond anticipation notes that we're looking to convert to long-term debt into general improvement bonds. Then there's another piece here for 86 million in short-term debt we're looking to issue in bond anticipation notes, and then 6 million in special emergency notes. This is all debt already authorized by council in prior year ordinances. So if there's any questions on the particulars there, I can answer them.
You have 10.4.
Yeah, I noticed that on the agenda, but I believe the law department is going, representing that one. Yep.
No, not yet.
Good evening, Council President, Council members. Jennifer Wong, Director of Traffic Engineering. I have 3 items to present. First item is item 3.4, Ordinance 25104. This is an ordinance designating reserved parking spaces at various locations. All locations were reviewed and approved at the September 3rd committee meeting. Next item, 1012, Resolution 25-617. This resolution is designating a loading zone at 911 Bergen Avenue. The loading zone would support the deliveries and loading needs of the building, and it would be in effect all days, all times. The final item, 1013, Resolution 25-618. This resolution is to designate a loading zone at 200 Monticello Avenue. The entrance to the Bergen Lafayette Montessori School is on Jewett Avenue, so the loading zone would be on the side street, and it would accommodate the pickup and drop-offs, the pickup and drop-off for the school. The loading zone would be in effect school days from 8 a.m. to 6 p.m.
That's the new building on Joey.
Yes.
Hey, Jennifer, quick question. Is someone else here from traffic for 3.2?
3.2.
Councilman, that's actually being withdrawn. That was made an error. A while ago, the council requested certain intersections that have no right turn on reds. I don't know why it said all property. I think it was an old, resolution or ordinance that got somehow pushed forward, but we're withdrawing that. That was made an error.
Oh, okay.
If you look at the actual notes of it at the very bottom, you'll see the intersections that were listed that came from individual council members.
Well, eventually we're still going to vote on those intersections, right? Okay.
Yeah, that one was already presented at the July meeting.
Okay.
So this was a duplicate of that ordinance. It was,
Just had that mix up.
The original ones were
Okay.
voted in July.
Thank you.
yeah, no problem. Thank you.
Good evening, Council President, council members. I am here to speak to Resolution 25-611, Agenda Number 10-6. This is a resolution awarding, or if you will, continuing a contract for Longview Technology Solutions to service our harm reduction kiosk that we have at the HHS building on MLK. This will continue through June 30th, 2026. The idea was initially to scale this out across every ward, but fiscal restrictions prevent that right now. So this just allows us to continue that contract for 1 year. I could speak to some specifics of the contract with them if you'd like. It so will not exceed the newly proposed bid threshold of $53,000. We're estimating it about $39,000, but there is a little bit of buffer there. We have a $14,000 gift / grant from the medical center to help offset those costs.
Thank you.
Thank you very much. Have a good evening.
Owen, I know that you were here for a resolution, but they telling me they just waiting for some approval. So if we get it by Wednesday, it won't be a problem. Okay? Thank you. Sean, take it from the top.
All right. On to our first readings, item 3.1, City Ordinance 25-101 is an ordinance of the Jersey City Municipal Council approving a tax exemption and authorizing a financial agreement with Sussex Street Associates regarding a project at 177 Grand and 193-195 Grand Street pursuant to the long-term tax exemption law NJSA 48:20-1 exec.
Yes.
Yeah.
Okay.
The applicant and NW Financial should be here as well.
Go ahead, Jim.
Good evening again. James McCann from law firm of Conifoli, appearing on behalf of the applicant for this tax abatement, Sussex Street Associates Urban Renewal LLC. This project is located on Grand Street between Marin Boulevard and Van Voorst. It's in the Paulus Hook neighborhood. It's 413 units. 62 affordable housing units included in that number. 7,500 square feet is being dedicated to OLC for use as a nursery school, and there's about 7,500 square feet of retail space with approximately 70 parking spaces. Question before the council tonight, I think, is I can tell you this is a very nice project. The question before the council is, why should you give this project a long-term tax abatement? And the answer is because it includes 62 affordable housing units in accordance with Jersey City's inclusionary zoning ordinance. And what that basically means is that in downtown Jersey City, in a place in Jersey City where it's very hard to get affordable housing, there'll be 62 affordable housing units. 21 of them will be low income, 10 of them will be very low income, 31 will be moderate income, and the majority of those units, which is 50, will be 2 and 3 bedroom units, which give Jersey City families a chance to move into the Paulus Hook neighborhood, downtown Jersey City. That's the first reason. The second reason is because the building will support the expansion of OLC, which is a neighborhood school that has been in Jersey City for a very long time and serves the population in the Paulus Hook and the surrounding downtown and other parts of Jersey City. And the developer is dedicating, as part of the amendment that was approved, is dedicating 7,500 square feet to that school to be used as another site so they can expand and have a nursery school in there. So those are two significant community benefits, I think, that the council can look to. There's a third, which is that for a very long time, St. Peter's Prep has been looking to round off their football field because they don't have enough room for a complete end zone on their football field. And it just so happens that this project is adjacent to the football field, and the developer is dedicating a little less than 1,000 square feet of its property that will then be able to be used by St. Peter's Prep to make their football field a little bit better and increase their end zone for the kids who go to that school and the fans. So that's really it. There's also a lot of employment that would be created. There estimate of over 400 construction jobs and 72 permanent or full-time jobs that will be built with this project, that will come with this project. And I think the really important thing is, and hoping that NW Financial will come up here and explain it to you in more detail, but this project is not going to get built without some form of financial assistance in the form of a tax abatement. And the reason why is because it is downtown in the Paulus Hook neighborhood, and the IZO was a great thing to stimulate affordable housing and get developers interested in it. But the real challenge behind the IZO is that we have to find a way to get the projects built. And the way financing is right now, the market is very difficult. And this project cannot be financed without a tax abatement that will create a consistent revenue stream over the first 15 years of the project. This project won't happen without this tax abatement. Or it will be very difficult or impossible for this developer to attract investors and lenders to finance this project, because the bottom line won't provide sufficient basis for the lender to justify it. So one of the important components of a long-term tax abatement is whether or not you pass the but-for test, which is but for the tax abatement, will the project get constructed? And in this case, I'm pretty confident the answer is no, it won't get constructed. And I think the 62 affordable housing units are the reason why the council should consider this favorably. That's my presentation. Happy to answer any questions that council has.
I think my questions are a combination, but I want to hear the financial presentation before I ask my question. In particular, the most important question I need to know is how much revenue will the city be collecting via taxes with and without the pilot?
But I think I can answer those questions, but if NW Financial's here, I'll defer to them. Hi.
Good evening, Council President, Council
evening.
members. Daniel Marinello, NW Financial Group. As with a lot of these projects that come before the city, our firm is brought in to analyze the developer's submission, review the financials that have been presented by the developer. We, as a firm, are an extension of the city in the sense that our job is to review it, provide you all with our financial analysis to determine whether or not, as the gentleman just mentioned, the law requires a but-for test. I mean, it's a bit subjective as the law is not specific as to that, but the question is whether or not the project as it is presented could be built from a financial standpoint, at least, if it was to receive conventional taxes. And so when we do that analysis, we look through, and we've provided a memo to the council. We look at, as with anything, it's cash flows, it's revenues versus expenses. We look and make sure that the revenues that are presented by the developer are accurate, reasonable, within the market of the area. We do the same thing from their cash flows on their expense side. And they've presented both. We actually have had many meetings back and forth, going back and forth with this developer. And just as a side note, we did not recommend and are not recommending the same pilot terms that the developer was originally requesting. We had gone back and forth to determine what we felt was a reasonable percentage for the pilot, the abatement, that both provided the developer cash flows in a financeable project, one that they would want to continue to invest in, while also providing the city with the revenues and stream of pilot payments. So in that vein, we look at, obviously, the current property is not producing a significant amount of revenues as much as it might under a new development. I believe the current taxes on these sites are about $630,000 a year. If this project were to be built as has been presented, based on the value and the cost of that project, using the current tax rate, that would be approximately $3.6 million a year. And so we put that number into the cash flows and we look at it as a bank might look at it. Would you underwrite this project at $230 million? If a bank was going to provide a loan to this project, they would want to see significant coverage on their loan. So one of the first things is to look at, does the cash flows allow for a 1.2 times coverage on your loan? Most banks actually would like to have more than that today, but the minimum they would do is 1.2 times coverage. The cash flows based on conventional taxes is below 1.2 times. Even 1.2 is difficult for banks today to get their arms around, but at conventional taxes, they wouldn't even get to that point. The other percentages that we look at, the matrix that we look at, is whether or not there's a yield on cost or an internal rate of return that makes sense for a developer who is about to invest, $50+ million of their own equity, along with a bank providing the rest of the loans. And yield on cost is essentially the cash flow divided by the total cost of the project. Most developers are looking for a return in that sense of approximately 6 to 7%, even higher today. Under the conventional taxes, God bless you. Under the conventional taxes, that return is somewhere just about 5%. So to think about that in real terms, the alternative, the risk of providing significant equity into a project like this to receive and only 5% returns is not something investors would be looking and interested to do. So we look at what are the alternatives, and the only real mechanism that we have as a municipality in the state of New Jersey is the long-term tax exemption law. often used as an abatement is the word, but it's not an abatement in such that the developer is not paying taxes. It's just referred to as a payment in lieu of taxes. And so what we try to do is negotiate that amount. We know that the 3.6 million of the conventional tax is too high for development of this sort, of this nature. As the gentleman mentioned, as the counselor mentioned, the affordable housing having 30%, 50%, and 80% of area median income rents in that building bring down the revenues a significant amount. It doesn't decrease the cost of the building. And so we try to look at and negotiate the number that does work. How do you get to a number for their responsibility for payments in lieu of taxes that also gives them returns that they might be acceptable for and a bank would want? And remember, I always think of it as a partnership in the sense that you really do want the developers to have returns because you want them to continue to invest in that building and you want them to do a really nice job, and you don't want something built there that is not going to be something the city could be proud of. So you want them to make money in the incentives. But at the same time, we need to make sure that they're paying what we believe the building from a revenue standpoint can pay. And we try to push that as much as we can. In this particular case, we ended at a 30-year term for the pilot, which the term is very important really on the lender side. It's really twofold. The banks, as the counselor mentioned, would like to see the term of the pilot match the term of a loan. It's the one line item in the tax, in the expenses of a development like this that the developer really doesn't control. And the banks know that. And so the banks, it's really important for the banks when they're underwriting projects like this to see that that tax line item is one that they can project forward for the term of their loan. So what we do is we tie it to revenues, and that's what the law allows for. So if the developer's revenues come in even higher than we are projecting, city shares in that benefit because the payment in lieu of taxes is based on the gross revenues of the project. So in this particular case, for market rate buildings, the law allows a minimum of 10% of gross revenues to be the pilot. In this particular case, we negotiated the first 15 years are going to be 12% of gross revenues. In the second 15 years, it would jump up to 13% of gross revenues. I mentioned before, regular taxes, it would be about 3.6 million. The gross pilot is going to be about, based on the rents and revenues that we think will be achieved in that area, about 2.5. So that's the difference as you're looking. You have $630,000 being produced at those properties today. Under the pilot, that number will go to about 2.5 million. And the city will receive that full amount of the 2.5 million. It's close. What happens in that situation is you have this, the gross pilot is paid, and then you have 5% goes to the county, and you also receive 2% administrative fee. And that's in the numbers that we presented to you.
So the difference per year, right now, they're taxing them, we're taxing them for vacant land 630. If they should get the pilot, it will be 2.5, and if they were able to build without the pilot, it would be 3.5.
If this were to be, I've always cautioned folks when I present that number of 3.5 million or 3.6 on conventional taxes, because that assumes the building would be built in the same fashion, right? So really what that number here is for illustrative purposes so that you can get an idea of what it could possibly be if it was conventional taxed, even though that building won't be built. Certainly not the same building that has been presented.
No, but I need a roundabout way to justify when someone say, Councilman, you voted for a developer to get a 30-year, $35 million abatement. So that's why I just needed that information. Now, my next question, maybe this is more for the administration. This land was essentially zoned from something to current, right, Peter? So if you can speak to that on the record, I think it was originally zoned. What was the original zone? It was a transition zone. So part of the benefit that developer got for being able to upzone was the triggering of the IZO and the community give back. So for me, looking at this project in totality is like, you've already broken that portion of the deal. Because if you build anything, you're gonna have to do 10%. Am I understanding that correctly or no?
I'm not following exactly. 10
It's 15%?
Downtown.
All right. But what I'm saying is,
about affordability? Is that what we're talking? I'm sorry, Council.
Talking about the IGO, Councilman?
yeah, what I'm saying is this land was already upzoned, right? Yes or no? Anybody?
I'm sorry, I can't speak to that.
The lawyer's here.
Yeah, I would have the lawyer address it. I think.
So, yes.
Okay, thank you. Land was already upzoned, right?
Pursuant to the IZO. Yes, there's an amendment to the redevelopment plan.
Yes, so what I'm saying is, that's not an incentive to give a pilot, because we've already given you the incentive to build a more denser project for the triggering of the IZ. I just want to make sure I'm understanding correct, because I know this is my first term and I'm not really familiar, but I do want to just make sure I'm understanding this correctly. Initially, it was one zone. We've obliged to upzone it for them to get more density, and for them getting more density, the give back was the school and the amount of affordability, whatever dictated down there via the IZO. Is that correct?
Yeah, correct.
That's all I need to know.
I think it's 15% affordable.
Yeah.
Councilman, the way you phrased the question, the answer is yes. The property was upzoned, but at the time of the upzoning, there was no financial analysis done as to whether or not the 15% affordable housing could be supported. That's not part of the land use process.
Okay.
You know, that's part of the financial the financing of the project comes after. So what the amendment did is it figured out a way how you could get a building on that site, and yes, create additional density, but it was from a land use perspective. There was never an analysis done as to whether the 15%, which was the goal, that was the goal of the IZO, was to get 15% affordable housing, whether that goal was realistic from a financial point of view.
Okay. No, I just want to make sure.
You're right. You're 100% right.
To
Yeah.
take all
You're
this
taking-
information in so I can make a sound decision.
Right.
And I just wanted to make sure that I was assessing the situation properly. That's all.
Right, but it was land use and then financing, and so that's
Yeah,
the,
James.
Sure, would you?
Good.
Have there been any buildings built in downtown using the 15% affordable housing without abatement? Or would this be the first one that's built, or do we have any information on that?
I think might be the first one that I've been working on. I don't know the answer to your question. If one has been built without.
Do you
Yeah,
know?
I'm just saying that might be more of a question for zoning and planning, and we get your response on that.
Yeah,
I
have any,
just want to put them on the spot for that.
have any developers been successful in essentially being a part of the 15%, like without abatement? So,
I mean, I can answer. I mean, so
ahead.
we have had, 3 or 4 lots that have had the zoning change, so now have the 15%. A couple of those developers say that they are moving forward to break ground without an abatement, but they haven't yet broken ground.
They haven't broken.
So, but if I could just say, I mean, this gets to, I think, the question, which is less for the applicant, but more for the council and the administration, which is to say, if this does move forward, I assume every developer who is developing at the 15% is going to say, well, the economics didn't work for these guys, doesn't work for us, and we're going to get a tax break. And, one of the things I had suggested earlier when this had come up was that we have a kind of policy that, so it's not one project moves forward, one project doesn't, but a clear policy around the IZO that says, look, if we say the economics don't work, we have a clear policy that applies to everybody as opposed to one individual project. So I just wanted to sort of state that concern. I did just want to ask for NW, could you produce an analysis for the council of what it would look like if this were required at 20% affordable housing as opposed to the 15? And obviously, I understand that the pilot payment might look different to the city, so you have to weigh those things. But if we're considering giving a pilot, I'd like to at least consider the economics of what it looks like to maximize the amount of affordable housing that's being delivered in that building.
Absolutely.
Okay.
Yeah. And one other thing I just wanted to add is part of the the payment in lieu of taxes. The law requires, as in addition to the percentage of gross revenues, there's a phase-in of regular taxes. So it is important. I did say that it's for illustrative purposes, the $3.6 million, which it is in comparing, would this be built or not? But it is an important part of the analysis over the 30 years. What the law requires is that over time, you start to phase in, the number gets closer to regular taxes.
Right.
The law actually says 20%, 40%, 60%.
Yeah.
The last 5 years will be at 80% of regular taxes. And the goal of that is so that when you get to the end of the pilot term, both the city, the payment is going to be close to what they would be paying in regular taxes by the time you get near the end. Most developers actually ask for 1 year of 80%, and 1 or 2 years of 60%, so that you don't hit that for very long. In this particular case, we've maxed that out and pushed back on that, so you get 5 years, 60%, and then 5 years of 80% at the end.
And I think just to highlight, like we work so hard to do the IZO. This developer's nailing the IZO, and he's providing 62 affordable and very low affordable units. I mean, he's doing what we asked, and I would imagine we should be okay with that because he actually nailed what we were asking for.
Thank you. Any more questions? Go ahead.
Is there any union or wage commitments in this pilot agreement, either for the construction or the permanent jobs?
Yes. So as part of city ordinances for a tax abatement like this, the applicant has to commit to complying with the living wage ordinance as recently amended by the council. That's number one. Number two, there's a PECA, project employment contract, attached to your packet. That's also part of this tax abatement.
Thank you.
Just one other thing. I will tell you that I've never seen in a tax abatement negotiation the numbers analyzed the way NW Financial has done it in this case. Councilman Solomon, I heard what you said about maybe the possibility of a policy, but I would also tell you, you're probably right. If this tax abatement gets granted, some more developers might come asking for a tax abatement. But if you only consider the ones that are complying with the IZO, that might not be such a bad thing because you can negotiate every single one with NW Financial and see whether a pilot is justified as it is in this case. And that might speed up the production of affordable housing in the downtown area.
So one more question, Jim. One more thing. And this is, something that maybe we can expand upon offline. But I know it was mentioned that there's up to 400 construction jobs. Councilman Solomon just asked some questions about construction. We get a lot of our local residents, contractors, people who are looking for work always, stating that they aren't privy to these construction jobs on the sites and, don't know how to bid on these jobs. Is there some type of wiggle room? I know some of the projects that we built recently in Ward A, we've had like an open house where people could come and speak with the general contractor to see what was available to build on. Can we see if maybe a developer is open to doing something like that if this passes?
Sure. This applicant is a local developer that's developed many projects in the city of Jersey City. I'll talk to them before before Wednesday and come back to you, Councilwoman.
Thank
But
you.
these people are not in the union. They have their own
Correct.
business, right? And I want that stated because I know I get those calls too, that there are some people who are skilled, but they're not in the union and they want to have a right to bid also. We just want to make sure that they have that opportunity.
Okay, I think we can figure that out.
Okay,
Thanks.
thank you.
Thank you.
Go ahead, Sean.
3.2, I believe, is going to be withdrawn at the Wednesday meeting. Item 3.3, City Ordinance 25-103 is an ordinance supplementing Chapter 332, Vehicles and Traffic, Article 3, Parking, Standing, Stopping, amending Section 332-31, parking restrictions for street cleaning purposes on Lincoln Park. Items 3.4 through 3.6 were touched on earlier. On to our second reading ordinances. Item 4.1, City Ordinance 25-096 is an ordinance amending Chapter A 352, enabling ordinances of the Jersey City Municipal Code, memorably designating Bentley Avenue from John F. Kennedy Boulevard to West Side Avenue in the city of Jersey City as Walter R. Lesniak Way. Item 4.2, City Ordinance 25-097 is an ordinance authorizing the execution of documents amending and releasing certain restrictions imposed on Block 15801, Lot 5, within the Jersey City Medical Center site to allow for its redevelopment. Item 4.3, City Ordinance 25-098 is an ordinance amending Chapter 218, multiple dwellings of the Code of Ordinances, the City of Jersey City by adding subsection 3, mandatory disclosure for rent increases, to Section 12 and correcting language in Section 1. 4.4 and 4.5 were touched on earlier. We are going to have a special going to have a public hearing on the 2025-2026 Exchange Place Alliance Special Improvement District Assessment Roll and Budget. We do have the attorney here to answer any questions that the council may have on the assessment roll and the budget.
Any questions?
No question.
No questions.
No questions. Thank you for being here.
Yeah, don't even, ain't no need to waste this,
Ain't time to
this
waste time.
steps.
Right, we have our request for a public hearing. Right now, we have 43 speakers. Next, any questions or comments on petitions communications 6.1 through 6.29? Hearing none, we have one office communication. Any questions or comments on that? Any questions or comments on reported directors 8.1 through 8.4? We have our claims and then on to our resolutions. Item 10.1 was touched on earlier. Item 10.2, City Resolution 25-067 is a resolution commemoration of the 85th anniversary of the Katyn Forest Massacre and the 86th anniversary of the German-Soviet invasion of Poland. Item 10.3 and 10.4 is what I just touched on earlier. It's the assessment roll and the budget of the 2025-2026 Exchange Place Special Improvement Districts. 10.5 is a resolution authorizing a license agreement between the City of Jersey City and the Jersey City Public Schools to grant Jersey City Public Schools exclusive use of the southwest corner of Paulus Hook Park during select hours. Item 10.6 was touched on earlier. Item 10.7 is a resolution appointing Julie Serrano as a member of the Jersey City Ethical Standards Board. Item 10.8 is a resolution reappointing Daniel Cronin as a member of the Jersey City Ethical Standards Board. Item 10.9 is a resolution appointing Philip Rivo as a member of the Jersey City Rent Leveling Board. Items 10.10 through 10.13 were touched on earlier. Item 10.14, Resolution 25-619 is a resolution increasing the city's bid threshold to $53,000 and authorizing the qualified purchasing agent to award contracts pursuant to NJSA 40A:11-3 and 19:44A-20.5.
Council, we just have to do this. The state has increased the bid threshold from 44,000 to 53,000. These new numbers took effect July 1st, 2025. So we're just authorizing our QPA, our purchasing agent, to issue window contracts, anything between 17.5 and now instead of up to 44, now it's 17.5 and up to 53,000. So those will not come before the council.
So anything below that $54,000 threshold is,
In between 17.5 and the $53,000. So you have to get two quotes and then the purchasing agent may award them.
got it. Thank you.
Okay. Item 10.15 was touched on earlier. Item 10.16, Resolution 25-621 is a resolution of the Jersey City Municipal Council authorizing a closed session on Thursday, October 2nd, 2025 at 5 p.m. to discuss issues related to pending litigation. Item 10.17 was touched on earlier. Item 10.18, Resolution 25-623 is a resolution appointing Patrick G. Patel as a member of the Jersey City Cannabis Control Board. That being said, may I have a motion to adjourn at 5:52 p.m.?
Motion.
Motion made by Councilperson Saleh. May I have a second?
Second.
Second by Council President Waterman. All in favor of the motion to adjourn at 5:52 p.m., all council members present by acclamation, please say aye.
Aye.
We are out of here at 5:52 p.m. Thank you so much.